welcome us in this event, let us call on the Director of the Institute of Human Rights, Professor Elizabeth Aguilin Pangalangan.
Good afternoon, everyone. Congressman Edsa Lagman, who is one of our favorites and who is our guest in several of our Institute of Human Rights fora. We welcome our distinguished guests, ladies and gentlemen. I hope that this isn't your first, nor will this be your last visit to the UP College of Law and Law Center. And today we are here for a very important mission, which is to talk about enforced disappearances. 3 years into office, President Benigno Aquino III has been rather slow in keeping his promise to hold accountable the persons responsible for serious human rights violations, including enforced disappearances. Although an improvement from the Arroyo presidency, which exalted former General Palparan of the AFP, the Aquino government has at least identified him and pressed charges against him for the alleged abduction, rape, and torture of UP students Sherlyn Cagapan and Karen Empeño. But until today, the charges were filed in 2011, but until today, it's almost, the Burr months. So almost, we're towards the end of 2012, and Palparan has remained a fugitive in hiding. Family members have pointed out that although President Aquino has said in 2010, on the occasion of the 67th anniversary of the International Declaration of Human Rights, that the culture of injustice, silence, and impunity is now a thing of the past. As of today, again, the government has not successfully prosecuted a single case of extrajudicial killing or enforced disappearance, including those committed 3 years ago, which means during the presidency already of Aquino. The Human Rights Watch, in its 2011 report, No Justice Just Adds to the Pain, documented 10 cases of extrajudicial killings and enforced disappearances since Aquino took office. No one has been arrested, they pointed out, in any of these cases, and the 3 disappeared people remain missing. The Institute of Human Rights is one of the 4 research arms of the College of Law. College of Law is the teaching arm, and the Law Center is the research arm. And we are one of the 4 institutes. It is our mission to promote and protect the human rights of citizens by providing relevant and timely research and analysis. This is why today we are very proud to launch the policy study undertaken by one of our law research specialists, Attorney Bombi Sunga, who will present a policy paper on the International Convention for the Protection of All Persons from Enforced Disappearances. Attorney Sunga will look at the challenges before us and proffers recommendations for the proper implementation of the right against enforced disappearance. We thank families of victims of involuntary disappearances, FIND, and the Asian Federation Against Involuntary Disappearances, AFAD, for co-sponsoring today's forum. We welcome and thank our speakers, Congressman Lagman, and the panel of reactors composed of Chair Eta, I hope that she will still praise this occasion, Brigadier General Tutaan, Dean Raul Pangalangan, Ms. Teresita Del Rosario, Ms. Nora Gomolo, and synthesizer and our Suki, Attorney Mirabel Cristobal, for their generosity of time and commitment to the cause. So I hope that you join me in looking forward to an edifying and productive discussion. Thank you and welcome once again.
Thank you, Professor Pangalangan. For opening remarks, let us all welcome the co-chairperson of FIND, or Families of Victims of Involuntary Disappearance, Ms. Nilda L. Sevilla.
Distinguished guests, fellow human rights advocates, families of the disappeared, ladies and gentlemen, magandang hapon po. August 30, 2011 was marked as the first United Nations International Day of the victims of enforced disappearance. However, even prior to the UN proclamation, associations of families of the disappeared have been observing the International Day of the Disappeared, or IDD, annually for several years already, every 30th of August. On this day, we pay tribute to the desaparecidos, their families, friends, and all those who support them and the causes they fought for. Today, as we salute and honor them, we are reminded of the harrowing experiences of both the disappeared and their families. While some families are resilient enough to accept the fate of their missing loved ones and transform their agony into courage, there are those who continue to agonize even as they hope for a miraculous reunion with their missing kin. Still, others need psychosocial interventions, even psychiatric help, for them to recover from the trauma and distress brought by the enforced disappearance of their loved ones. Drawing strength from one another, the relatives of the disappeared in various countries across continents have formed associations of families, including federations, and have been one in their campaign against enforced disappearance and for justice to the victims and their families. Impelled by their desire to know the truth about the fate and whereabouts of the disappeared and bring the perpetrators to justice, the families of the disappeared, led by the Latin American Federation of Associations of Relatives of Disappeared Detainees, or FEDIPAM, relentlessly campaigned for the adoption of a convention on enforced disappearance. In 1982, FEDIPAM drafted the convention and submitted it to the UN Working Group on Enforced or Involuntary Disappearances the following year. Aside from publishing the text in its annual report in 1984, the working group did not take any more significant action on it. There were other initiatives on the regional and international levels that sought to address enforced disappearance alongside the efforts of FEDIPAM. These bore fruits in the adoption of the UN Declaration on the Protection of All Persons from Enforced or Involuntary Disappearance in 1992, the Inter-American Convention on Forced Disappearance in 1994, and the Rome Statute for the establishment of the International Criminal Court that took effect in 2002 and listed enforced disappearance as a war crime and a crime against humanity when committed as part of a widespread or systematic attack directed against any civilian population. Not satisfied with these instruments, the associations of families of the disappeared and their federations continued to push for the adoption of a separate, legally binding instrument that could address the limitations and weaknesses of the existing instruments. With the exceptional diplomatic skill, dedication, and commitment of the late French Ambassador Bernard Bessetran, who was at the helm of the UN Commission on Human Rights Intersessional Open-Ended Working Group, the drafting of the convention was completed in a relatively short time, on December 23, 2005. Finally, on June 29, 2006, the United Nations Human Rights Council adopted a resolution endorsing the convention to the United Nations General Assembly, which in turn approved it on December 20, 2006. It entered into force on December 23, 2010, and has now 93 signatories and 32 states parties. The Philippines, notwithstanding its commitment to support the convention as one of its pledges to the United Nations Human Rights Council in 2007, has yet to sign the convention. This afternoon, the Institute of Human Rights will formally present a policy paper on the convention that can help urge the Philippines to sign and ratify the convention, even as our keynote speaker will share the Philippine experience in the campaign against enforced disappearance more particularly through the enactment of a penal law on enforced disappearance that complements and reinforces the convention. Maraming salamat.
Thank you, Ms. Sevilla. Next, let's welcome Ms. Wilma Tizon, the Deputy Secretary General of the Families of Victims of Involuntary Disappearance, to give acknowledgements.
I'm pleased to acknowledge the following participating organizations and embassies, academe, and from the media. From participating organizations, we have the UP, of course we have from the organizers, UP Institute of Human Rights, Families of Victims of Involuntary Disappearance, Asian Federation Against Enforced Disappearances, International Coalition Against Enforced Disappearances, Coalition for the International Criminal Court, Bukluran ng Magagawang Pilipino, Kongreso ng Pagkakaisa ng mga Maralitan ng Lungsod, Children's Legal Rights and Development. We also have representatives from the Samahan ng mga Anak ng Disappearances. We have also from the Kilusan para sa Pambansang Demokrasya or KPD. We have na manggagawa para sa kalayaan ng bayan or makabayan. Youth for Nationalism and Democracy. Kaisa pa youth. Katarungan youth. Katarungan. From the government, we have representatives from the Office of the Presidential Advisor on the Peace Process, the Department of Foreign Affairs, Commission on Human Rights, Armed Forces of the Philippines Human Rights Watch, from the Office of Senator Miriam Santiago, and from the diplomatic community we have representatives from the Swiss Embassy, the Australian Embassy, and from the European Union. From the Academe, we have reports from the UP College of Law, the LaSalle University, Free University of Berlin. We have from the UP Paralegal Volunteers Organization. We have also from the UP Asian Center. And direct from Canada, we have from the University of Montreal, Justin. From the media, we have from the Manila Times.
Our keynote speaker today needs no introductions. He is the esteemed gentleman from the 1st District of Albay. He has been consistently chosen as Outstanding Congressman every year from 1987 to 1998, then from 2004 to 2008. Over the years, his capability as a statesman was shown in a number of major laws he authored, including Republic Act 8532, an act strengthening further the Comprehensive Agrarian Reform Program, or CARP, Republic Act 6728, providing financial assistance to students and teachers in private institutions, and Republic Act 6655, establishing and providing a free public secondary education. He is an advocate of criminalization of involuntary disappearance and promotion of human rights. He is a lifetime honorary chairperson of Families of Victims of Involuntary Disappearance and the founding chairperson of Asian Federation Against Involuntary Disappearance. Here to grace us this afternoon, let's give a warm welcome to Honorable Edsel Lagman.
Thank you for that kind introduction. Ang daming participants na pinangalanan si Willie. Sana yung mga dito ay hindi biktima ng enforced disappearance. For a long time, I have been typecast as an advocate of reproductive health. But even before I was an RH advocate, I have been a crusader for human rights for a long time already. That is why it is my great pleasure to be here with you this afternoon to discuss the most odious violation of human rights, that is enforced disappearance. After 35 years of searching and fighting for justice for a desaparecido son, Attorney Herman Silagman, a human rights and labor lawyer who disappeared during martial law, my mother, Mrs. Cecilia Casares-Lagman, founding chairperson of FINE and a member of the first board of directors of the Bantayog ng Mga Bayani Foundation Incorporated. On August 13, 2012, joined her creator and other relatives of the disappeared who have gone ahead of us. It is indeed lamentable that after the long and relentless fight, relatives of the disappeared grow old and die without finding their missing king, and even as justice for the extremely odious act remains elusive. While most of the families of the disappeared fail to locate their missing king, in the words of former Senator Obito Salonga, and I quote, "In a profound sense, we have already found them, and we are finding them whenever men and women continue the valiant struggle for truth, freedom, justice, and national sovereignty. We find them whenever the youth of the land offer their talents, energies, and resources for a cause bigger than life itself." The campaign against enforced disappearance therefore interlocks with the people's struggle for a liberating truth, empowering democracy, enduring peace built on justice, and respectable sovereignty. These were the unshakable dreams and aspirations that our disappeared heroes and martyrs steadfastly sought to realize, and for which they selflessly sacrificed liberty and even their life. The collective struggle for freedom and life with dignity and honor does not end with the enforced disappearance of an activist or advocate. To paraphrase Senator Salonga, the disappeared are resurrected in the men and women who courageously sustain the struggle for the causes fought by the martyrs of social and political transformation. As the struggle continues, history constantly reminds the inheritors of the past to uphold human dignity and protect all persons from human rights violations. The most cruel among these transgressions, and one that violates practically all human rights, is enforced disappearance. A global tool of political repression, enforced disappearance is practiced by no less than 87 states, including the Philippines. We surmise that the campaign against enforced disappearance in the country had its steerings in the first anguished cries of protest from the relatives, comrades, and colleagues of the early desaparecidos. Since these political activists belong to politicized middle-class families, it did not take long for 9 of the grieving families to band together and decide to collectively fight against enforced disappearance and for justice for their missing loved ones.
Sir, tanggalin ko
Thus,
sana.
on November 23, 1985, the Crismo, Del Rosario, Lagman, Untong, Pagdalis, Reyes, Romero, Kayak, and Yap families founded the Families of Victims of Involuntary Disappearance, or PAID, with the invaluable assistance of the Task Force Detainees of the Philippines, notably its then chairperson, Sister Mariani Libarana. Henceforth, PAID has taken the lead in the organized campaign against enforced disappearance. The guiding direction of the campaign is to transform the crusade against enforced disappearance from a familial mission into a bigger societal agenda by the human rights community with PAID as the hand. Securing public support for the fight against enforced disappearance is imperative against the prevailing culture of impunity. The call to hold government authorities, more particularly the security forces, accountable for acts of enforced disappearance had for many years fallen on deaf ears. Persistent collective efforts of human rights advocates and defenders to engage concerned authorities in addressing enforced disappearance have in no small measure enlightened certain individuals and officials in government on the urgency of instituting protection from enforced disappearance and of putting an end to impunity. Consequently, after languishing in seven congresses, the anti-enforced disappearance counterpart bills have been approved by both the House of Representatives and the Senate. The House last Tuesday elected 7 of its members, namely Representatives Neil Tupas Jr., Rene Lampagos, Lorenzo Tanyano III, Carlo Alexis Nograles, Magtanggol Mundo, Carlos Padilla, and this representation as conferees to the bicameral Conference Committee on House Bill number 98 and Senate Bill number 2817 or the anti-enforced or involuntary disappearance bill. The Senate has yet to elect its conference. I hope that's true. House Bill number 98 and Senate Bill number 2817 have no significant disagreeing provisions, except for some differences in style, absence in either version of counterpart provisions which are not really overriding, and the lack of an appropriation language in the Senate bill. We expect a smooth sailing by Cabinet Conference Committee soonest. I am confident that the President will sign the enrolled bill once it is transmitted to Parliament. It should be recalled that the anti-enforced disappearance bill has been in the House of Representatives since 1990, or 22 years ago. Ang buong akala ko, ang pinakamatagal ng krusada sa Kongreso ay yung abolition of the death penalty. It took us only 20 years. And the next longest in this nation is the reproductive health bill. The first bill that sought to criminalize enforced disappearance was not supported by mine and other human rights organizations because it imposed the death penalty on the perpetrators. Just being consistent of the advocacy of the human rights exponents to do away with the death penalty. In the 9th Congress, the late Representative Bonifacio Iliego of Sorsogon introduced a new anti-disappearance bill that imposed reclusión perpetua as the greatest of penalty. When I returned to Congress in 2004, I immediately filed a revised version of the bill which was later consolidated with similar measures. This bill was approved by the House on third and final reading and promptly transmitted to the Senate, which unfortunately failed to approve their counterpart nation. In the following 14th Congress, I reintroduced the bill, which was also passed by the House, but the Senate again was unable to approve its own version of the bill. I'm not saying that the Senate is the graveyard of progressive legislation. Among the common stated provisions of House Bill number 98, which I principally authored, and Senate Bill number 2817, the current bills in the 15th Congress, are the following. 1. Penalizing enforced disappearance as a separate criminal offense. 2. Adopting the United Nations definition of enforced disappearance that principally makes liable agents of the state and excludes non-state actors as perpetrators. 3. Declaring the right against enforced disappearance as a non-derogable act or cannot be suspended under any circumstances, including political instability, threat of war, state of war, or other public emergencies. 4. An act constituting enforced or involuntary disappearance shall be considered a continuing offense as long as the fate or whereabouts of the victim is unknown. Inapplicability of the statute of limitations for victims whose fate and whereabouts remain unclarified. 6. Maintenance of up-to-date registers of detainees and prisoners. 7. Expeditious disposition and enforcement of court orders and rulings. 8. Penal sanctions ranging from arresto mayor to reclusión perpetua. 9. Preventive suspension or summary dismissal if warranted of perpetrators. 10. Liability of offenders under national criminal laws. 11. Inapplicability of double jeopardy under international law. 12. Criminal liability of commanding officers or superiors. 13. Right to disobey an order to commit enforced disappearance. 14. Exclusion of offenders from amnesty and similar measures. And 15. Restitution of honor, monetary compensation to and rehabilitation of victims and next of kin. A law criminalizing enforced disappearance is of overriding significance in bringing perpetrators to justice. No existing penal law captures all of the constitutive elements of enforced disappearance, which must be a distinct offense. However, in the absence of a law penalizing enforced disappearance, some families of the disappeared require kidnapping and serious illegal detention and or murder against suspected perpetrators. Until now, they have not seen the light at the end of the tunnel. It is high time that we label as enforced or involuntary disappearance the act of the private person of his or her liberty by state authorities, followed by a denial of the arrest, abduction, or detention, or concealment of the fate or whereabouts of the victim. A law criminalizing enforced disappearance as a separate offense would facilitate the filing of appropriate criminal charges against the offenders and hopefully deter others from committing the same odious multiple violation of human rights. Legal protection from a global menace must be guaranteed in both the national and international levels. Hence, the relentless campaign for the Philippines to enact a domestic law penalizing enforced disappearance and to sign and ratify the International Convention for the Protection of All Persons from Enforced Disappearance. While and APAC actively participated in the final drafting of the Convention in the United Nations in Geneva and joined other association families of disappeared in lobbying for the adoption of the Convention by the United Nations Human Rights Council and subsequently by the United Nations General Assembly. In fact, both FINE and APAD delivered oral interventions to urge the UN Human Rights Council to adopt the Convention at the Council's opening session in June 2006. Moreover, the International Coalition Against Enforced Disappearance, of which FINE and APAD are members, with APAD serving as the current focal organization, has been lobbying states across continents, more particularly in Asia, to sign and ratify the Convention and recognize the competence of the Committee on Enforced Disappearance that would monitor state parties' compliance with the provisions of the Convention. I think to a certain extent they have been successful in other countries. I hope they will be successful in our own country. I do not wish to preempt the presentation of the policy paper on the Convention by the Institute of Human Rights of the UP Law Center, but I assure you that the proposed anti-enforced disappearance law and the Convention are complementary and mutually reinforcing. Their full implementation would undoubtedly strengthen legal protection from enforced disappearance, even as it would promote human rights and civil liberties and uphold the rule of law. It would serve as an enduring tribute to the desaparecidos and their families who have kept the flame of courage incessantly burning in pursuing the vision of the disappeared, of a society and a world free of exploitation and human rights violations. On a personal note, I dedicate the soon-to-be enacted anti-enforced or involuntary disappearance law to my late human rights advocate mother, Mrs. Cecilia Castellan-Lagman. This was also intimated to me by Representative Lorenzo Tagliani III, another author of the bill, during my mother's life. Maraming po salamat po sa inyo.
Thank you, Congressman Lagman. Our next speaker is a law reform specialist in the Institute of Human Rights. He is also a professorial lecturer at the UP College of Law. To present the paper entitled International Convention for the Protection of All Persons from Enforced Disappearance, Prospects and Challenges, we now call on Attorney Ricardo A. Sunga.
Thank you for the kind introduction. We will just put up the PowerPoint presentation. Thank you for that kind introduction, Diane. Congressman Lagman, honored guests, dear friends, allow me to walk you through the research and policy paper prepared by the UP Institute of Human Rights. Next slide, please. These are the parts of the research and policy paper. The first part examines the nature of the violation that the enforced disappearance constitutes. The second part evaluates the sufficiency of existing laws. The third part explores the provisions of the International Convention for the Protection of All Persons from Enforced Disappearance, the subject of the research and policy paper. I will refer to this convention simply as the Disappearances Convention. The next part makes some conclusions and recommendations. Next slide. For the nature of violation, next slide. We could consider the different elements of the enforced disappearance. 4 international documents define the enforced disappearance. There is the UN Declaration on the Protection of All Persons from Enforced Disappearance. There is also the Inter-American Convention on Forced Disappearance of Persons. There is also the Rome Statute establishing the International Criminal Court that defines the enforced disappearance as a crime against humanity. The 4th document is the subject of our research and policy paper, the Disappearances Convention. The definitions in these documents have 3 common elements. The first is that the ones responsible are agents of the state or public officials. The second element is that there is a deprivation of liberty. The third element is that this deprivation of liberty is concealed by the agents of the state or public officials. Next slide. Strong words have been used to characterize the enforced disappearance. Here's an example. These words are taken from the UN Declaration on the Protection of All Persons from Enforced Disappearance. And I quote, that enforced disappearance undermines the deepest values of any society committed to respect for the rule of law, human rights, and fundamental freedoms, and that the systematic practice of such acts is of the nature of a crime against humanity. Next slide, please. Here is another quote. Again, there are strong words to characterize the enforced disappearance, and I quote, the disappeared are denied a place among the living and also denied a place among the dead. End of quote. As asserted in the research and policy paper, the enforced disappearance robs the families of the disappeared not only of the company of the disappeared relative, but also of a way of remembering this disappeared relative. Psychologists and sociologists have done studies in the effort to describe the harms suffered by those affected by this violation known as the enforced disappearance. Blau and Latenmaki have, for example, found, and I quote, it has been found that the family members of missing persons have more anxiety and post-traumatic stress disorders than family members of dead persons. They may suffer from insomnia, preoccupation with thoughts of the deceased, and unpredictable periods of anxiety, anger, survivor guilt, numbing of emotions, and withdrawal from other people. These symptoms are typical for both chronic unresolved grief and post-traumatic stress disorder. Different authors have called the suffering experienced by the families of the disappeared as complicated grief. The grief is arrested. The mourning process is not completed by the fact that the fate of the disappeared person remains unknown. Next slide, please. Quirk and Casco is another example of a study. And here, there is a comparison between the experiences of the families of the disappeared and the families of those who have experienced a death among their relatives. And Quirk and Casco have documented higher levels of grief and longer periods of grief on the part of the families of disappeared persons. Next slide, please. The research and policy paper asserts that the enforced disappearance is of a nature and gravity unlike any other. Nia Yolen, an author, in relation to violations of women's rights, discusses the need for the law to capture more fully the experiences of those affected by violations. The same analysis and language can be applied to the enforced disappearance. And thus, the research and policy paper argues, and I quote, "A deeper understanding of the violation of the enforced disappearance is important for the victims to come to terms with their experiences and to translate this knowledge into legal form." Next slide, please. The second part of the research and policy paper assesses the sufficiency of existing provisions. Next slide, please. For international treaty law, there are the provisions of the International Covenant on Civil and Political Rights and the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment. The provisions of the Covenant, ICCPR, have been used by the UN Human Rights Committee that implements the Covenant to give effect to the right not to be subjected to enforced disappearance. We can look at decisions like Quinteros versus Uruguay and Sarma versus Sri Lanka, in which the UN Human Rights Committee creatively interpreted the Covenant and said that the enforced disappearance puts at risk of violation several human rights guaranteed under the Covenant. These include the right not to be subjected to torture or other cruel, inhuman, or degrading treatment or punishment, and the duty on the part of states parties to investigate violations of human rights. For its part, the Committee Against Torture that implements the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment has declared in its concluding observations on the United States of America that the enforced disappearance is a form of torture. Next slide, please. While these international human rights treaties provide legal basis for implementing the right not to be subjected to enforced disappearance, the research and policy paper asserts that these international human rights treaties fall short of full recognition of the right not to be subjected to enforced disappearance. They still do not come up to the standard of a comprehensive measure that addresses the violation that is known as the enforced disappearance. Insofar as domestic law is concerned, the research and policy paper looks at Philippine laws like the revised Penal Code of the Philippines that defines and punishes crimes like kidnapping and arbitrary detention. Kidnapping is committed generally by private individuals, unlike the enforced disappearance, which by definition is committed by agents of the state or public officials. The crime of arbitrary detention is committed by agents of the state or public officials. However, arbitrary detention, just like kidnapping, does not include among its elements the concealment of the fate of the disappeared person, an element that is central to an enforced disappearance. Next slide, please. Both at the international level and the domestic level, existing provisions fail to capture fully the experiences of the victims of enforced disappearance. The provisions are scattered, with no clear indication of what the title is. There's a need for a law, both at the international and domestic level, that increases the level of protection for enforced disappearances, captures the harms experienced by the victims of enforced disappearance, clarifies the nature and scope of the right not to be subjected to enforced disappearance. Next slide, please. This next part explores the provisions of the Disappearances Convention. For the substantive provisions, next slide please, we can take a look at the absolute prohibition of enforced disappearances. This prohibition is not subject to any derogation, whether in time of war or any other public emergency. The Convention obliges states parties to define and criminalize enforced disappearance. Next slide. The covenant goes further and identifies conditions necessary to prevent enforced disappearances and to put a stop to those that have already started. For instance, the convention requires a thorough and impartial investigation by states parties into cases of enforced disappearances. It also prohibits secret detention. Secret detention is the very negation of the right to know the truth about disappeared persons. The convention also requires registers of detainees and requires, in relation to this, means of reliable verification of the release of detainees. Next slide, please. For the remedial provisions of the Disappearances Convention, next slide, please. The Convention establishes the Committee on Enforced Disappearances to monitor the implementation of the covenant. Next slide, please. The Convention equips this committee with these monitoring provisions. Next slide. We could compare classical procedures with current procedures implementing human rights provisions. We could, in this relation, compare charter-based procedures with treaty-based procedures. Charter-based procedures trace their authority ultimately to the UN Charter. Treaty-based procedures trace their authority to specific human rights treaties. Next slide, please. For charter-based procedures, the classical procedure is the 1503 procedure. It is an individual petitions procedure that is confidential. Its scope is limited to systematic violations of human rights. For the for the current procedures, we could keep in mind that the 1503 procedure is actually still there. Included as well is the range of special procedures. You have the special rapporteurs and working groups. They are able to conduct visits to the territories of states and respond to urgent action requests. There is also the Universal Periodic Review, a kind of reporting procedure. It is public in nature, and it is carried out by the United Nations Human Rights Council, the successor of the UN Commission on Human Rights. Next slide. For the treaty-based procedures, the classic monitoring procedures are the reporting procedure, which enables the treaty body to receive periodic reports from states parties on steps they have taken to implement the provisions of the human rights treaty. The individual communications procedure makes possible complaints from individuals to the treaty bodies about violations committed by states parties. The interstate communications procedure enables a state party to complain about violations being committed by another state party. For the current procedures, we have all of these procedures still there. In addition, there is the inquiry procedure. It makes possible visits to the state party, to the territory of the state party. And what triggers the procedure is serious violations of human rights. The next procedure is the urgent action procedure. This procedure is specific to the Disappearances Convention. It enables the Committee on Enforced Disappearances to receive requests and act on requests that a particular disappeared person be sought and found. A referral procedure enables the Committee on Enforced Disappearances to bring to the attention of the United Nations General Assembly through the Secretary General systematic violations of the Disappearances Convention. The last procedure is the system of unrestricted and unannounced visits. This procedure is only available before the Subcommittee on the Prevention of Torture under the optional protocol to the Convention Against Torture. All of these procedures are actually available to the Philippines except those under the Disappearances Convention for the reason that the Philippines is not a party to this particular convention, as stressed a while ago by our colleague. Let us go back to a slide earlier, the one before that, and the one before that. Thank you. These are the procedures available under the Disappearances Convention. It's a bit like throwing the entire book at the enforced disappearance. You have the drafters coming up with a lot of the procedures. Some of the procedures build on the practices and procedures of other treaty bodies as well as charter-based bodies. For example, the urgent action procedure of the Committee on Enforced Disappearances actually builds on the urgent action procedures of the special rapporteurs, and working groups. Specific to enforced disappearances, you have the working group on enforced or involuntary disappearances, which was also cited a while ago by our colleague. And the final note on the procedures. These procedures actually have novel elements not found in other human rights treaties. Next slide, probably 4 slides down. Yes. The research and policy paper of the UP Institute of Human Rights recommends that the Philippine government ratify the Disappearances Convention. It raises the level of international legal protection. It details the right not to be subjected to enforced disappearance. It clarifies the different dimensions of this right. And it captures more fully the harms experienced by the victims of enforced disappearances. It also provides a range of monitoring procedures that possess some novel elements. Next slide, please. While the Institute of Human Rights of the University of the Philippines recognizes that the Disappearances Convention is an answer to enforce disappearances, the Institute also recognizes that it is not a complete answer. Beyond the possibility of ratification of the Convention, there's a need to look at the administration of justice in the Philippines. Next slide, please. Issues of consistency and evenness in the administration of justice and enforcement of our laws have been raised. There is a need to address these issues for a fully functional system of administration of justice and for a full enjoyment of the right not to be subjected to enforced disappearance. Thank you for your kind attention.
Alright, thank you, Attorney Sunga, for your enlightening presentation. I'm sure we all got very useful insights. And now to give the reactions, let's welcome the panel of reactors. Our first reactor will speak in behalf of Chairperson Eta Rosales. We have Attorney Byron Bocar. He's an executive assistant of in the office of the Chairperson in the Commission of Human Rights. Please let's give him a warm applause.
Thank you. So first, in behalf of Chairperson Eta Rosales, her apologies for not being present in this very important forum because she's now in Myanmar on official business. So I was asked to participate in behalf of the Commission on Human Rights. I think this forum is very important in terms of human rights because it gives us much hope that the human rights of all persons in the Philippines against enforced disappearance will be protected. Congressman Lagman discussed earlier about the bills of the Senate and the House that are now going to be discussed in a bicameral conference committee. So we will be seeing soon the enactment of an anti-enforced disappearance law. This follows the enactment in 2009 of the anti-torture law. These two bills, when they were still in Congress, used to be discussed one with the other. But somehow the bill on forced disappearance lagged behind. But now finally, we're happy that it will finally be approved. And the presentation of Attorney Sunga about the Convention against enforced disappearances is also very important because it emphasizes the need at the international level, the level of the international conventions, for protection measures and remedies and procedures to be put in place by the government by signing and ratifying the Convention for the Protection of All Persons Against Enforced Disappearances. The protection mantle would not be complete, one without the other. We need both domestic law and international law protection is represented by the International Convention for the protection to be complete. Otherwise, there will always be what I would call an impunity gap. Whenever or wherever acts of enforced disappearances are not covered by either the domestic law or by the lack of or the failure to ratify the International Convention, would mean that people will still go scot-free for committing these very heinous and, as Congressman Lagman said, very odious crimes. And we have seen the effects on the families of the disappeared that have been discussed by Attorney Sunga. So we hope that this forum would be the start of a campaign by all stakeholders to push for the ratification of the convention, now that Congress is about to approve the bill. The way that the anti-torture law was passed was there was already a Convention Against Torture ratified by the Philippines way before that, and then there came the Convention Against Torture, and that was followed by the ratification of the optional protocol for the Convention Against Torture. Those were the set of measures which, insofar as torture is concerned, more or less completed the mantle of protection, to repeat the phrase, against torture. We should do the same with respect to enforced disappearance. But there are certain questions that I would like to raise in connection with the issue of protection. As Congressman Lagman discussed earlier, the bill that's going to be approved soon by Congress applies to state actors because that is how enforced disappearance is defined by the convention. That means the non-state actors are not included in the bill. The convention, however, has a provision which follows the definition, which enjoins states parties to take all steps to investigate persons who committed the same acts as defined in the previous article, Article 2, which defines enforced disappearances, committed by persons who are not authorized by state authorities. In other words, it effectively extends, my interpretation, it effectively extends the definition or the coverage of anti-enforced disappearance to persons who are not authorized by the state or not under its acquiescence, or act without its acquiescence. Because the definition provides clearly in Article 2 state actors, and second, persons acting with authority, instruction, or acquiescence of the state. Article 3 applies to persons who commit the acts defined in Article 2 but are not authorized by the state. So the question arises, if the bill becomes law, which we think it will, and if the convention is ratified, which hopefully it should, the question is, will the state obligation defined in Article 3 for the state parties to take all steps to investigate and bring to justice persons who commit the same acts as state parties and authorized persons, would that mean that it, as part of its obligation under the convention, that a corresponding legislation should have to be passed? Because then, under that interpretation, that would extend the mantle of protection to victims of enforced disappearances committed by non-state actors. There is already just existing legislation, which is the IHR law, the law which defines and penalizes violations against international humanitarian law, Republic Act 9851. And there is a mention there of enforced disappearances under crimes against humanity. But as also provided for in the Rome Statute, from which the provision came from, this has to be part of a widespread and systematic attack on a civilian population with knowledge of the attack. There are certain conditions and threshold requirements similar to that of the Rome Statute. So in other words, there are still, and while 9851, Republic Act 9851 applies in the definition of enforced disappearances under its definition of terms, applies to non-state actors, similar to the coverage of the Rome Statute. I think the threshold adopted, which is that of the Rome Statute, is quite high and would not cover other cases of enforced disappearances committed by non-state actors below that threshold. And so that leads me back to my point of the mantle of protection. Perhaps the mantle of protection would still not be complete. There might still be an impunity gap. So those are some points which I raise at this point, but I think the prospect right now of the anti-enforced disappearances bill being enacted into law is very good. Finally, it will become law, and it also brings to mind what was mentioned earlier by Congressman Laman, My good friend who was a victim of enforced disappearance during martial law, attorney Herman Lagman, and others also like him who were the victims of enforced disappearance. The bill's approval would also ensure other duties and functions which involve the Commission on Human Rights in order to further strengthen the mantle of protection, including reporting mechanisms involving the Commission, oversight functions, visitation functions, etc. So these are all new functions and obligations that will be assumed by the Commission on Human Rights gladly, so long as there is already an enacted legislation to be followed hopefully by a ratified convention. So I'll end my reaction at that, and maybe we can discuss this later on after the others are reacted. Thank you.
Thank you for that reaction, Attorney Bucar. Now, before we proceed, let us acknowledge the presence of these organizations. The Task Force Detainees of the Philippines. There's also the students of Pasay City High School, who joined us. Also our media partner, TV5. There's also the Law Student Government of the University of the Philippines College of Law. Also, BMP, which stands for Bukluran ng Manggagawang Pilipino. And last one, the Local Resource Center of Burma. Alright, for our next reactor, for our second reactor, we have the Chief of the Armed Forces of the Philippines Human Rights Affairs Office. He is a staunch advocate of enhancing the culture of human rights, international humanitarian law, and rule of law within the AFP. We now call on Brigadier General Domingo Tutaan Jr.
Thank you very much for the kind introduction. Ladies and gentlemen, magandang hapon. It is for another reason that when we were looking at the study, we saw that the prospects, if you look at the title of the story of the study, it's Prospects and Challenges. On the prospects, we are also very confident that these prospects really would enhance the ability of the state to be able to protect all persons from enforced disappearance. As I was listening to Attorney Bucar, he made mention of Article 3, which is the state responsibility to investigate. But allow me also to emphasize that the Armed Forces of the Philippines, and the defense establishment as a whole, is also one with the very, very first article, Item 1 and 2, Part 1, Article 1 of the conventions. So that it is a matter of doing everything on a collaborative basis to make sure that enforced disappearances are ended. And that if there are, especially those incidents in the past, this may be put within a just conclusion or just resolution within the due process of law. The challenges, therefore, is where we would like to look into. As we feel optimistic about the approval or the promulgation of the bill into law and probably the ratification of the convention, we look at the challenges at hand. We look even beyond that already, and looking at it from what was said in the last two slides of our presenter as far as the study is concerned, it is really that the convention is an answer to this, but it is not a total answer to everything. What I'm trying to drive at is on the matter of us joining each other to enforce or implement the law. A clear example, probably, just to put an analogy on what I'm trying to say, is that Republic Act 9851, entitled The Crimes Against IHL, Genocide, and Other Crimes Against Humanity, was promulgated in 2009. I believe up to this date, 2 years, 3 years thereafter, there is no one single case filed in violation or in as far as 9851 is concerned. This is what we're trying to look into as a matter of challenge. And that is the reason why we will work on this paper to look into how we can now put procedures and probably mechanisms for us to be able to enforce the provisions of the bill and soon to be a law. Just like what the Honorable Congressman has made mention that a violation or a conduct of enforced disappearance would now be a separate crime, would now be punishable with peclusion perpetua. Very fine. But these things all will come when a case is filed in court. Rule 110, I don't know, I'm no lawyer, probably Rule 110 of the Courts of Criminal Courts Procedure, I think so, is that the commencement of a case is always with the filing of a case before the court. And this is where we would like to partner ourselves with all the groups here. I have been partnering, my office in representation of the Armed Forces of the Philippines have been partnering with AFAD and FINE primarily because they're the two organizations I've been in contact with very almost every now and then in order that cases may be filed. Article 3, as what Attorney Borcam made, is on the investigation. Let me just put it in some perspective. The Armed Forces of the Philippines is an investigative body in itself, but it is not an appropriate investigative body as far as procedures of court is concerned in rules of evidence. The AFP does not have post-mortem examination. The AFP does not have ballistics examination or any other examinations that are most probably within the Philippine National Police and the NBI. So the thing here right now is that we will be able to partner ourselves as a stakeholder engagement towards affecting that bill or the law, hopefully, if I may call it already, the law on ED, that we will be able to implement it. Allow me, Ma'am, to say that a month ago, I was in a meeting with AFAD and FINE in Malacanang with the PHRC, and I have received from them the list of cases that they are investigating as far as the period of July 2010 to date. I think there was period ending June 2012. There are 18 cases, reported cases, or incidents of enforced disappearance. We have looked into them, and this is, even if we have a law already, what is more important is this for 18 incidents to be filed in court. And that is the reason why what we're like to envision right now as a matter of challenge, as presented in the study, is to work with a mechanism or a procedure on how we can jointly, AFP, PNP, government, CSOs, NGOs, and what have you, be able to have this incident be filed in court so that we can get at those who are perpetrators of this heinous crime of enforced disappearance. And in this manner, be able to end impunity and be able to make sure that all persons are protected against enforced disappearance. And thus, the challenges presented is the one we are very much eagerly looking into right now. Even if the bill is yet to be approved and promulgated, we would like now to start off coming with how to make these procedures. There are also challenges, as I was talking to one of the participants here, is also on the differences of information. Let's say NGO or CSO1 has this information, and let's say AFP has this information, which are not congruent with each other. Who says who's right? Who says who's going to be considered as a matter of if there was a crime of enforced disappearance? With the law of ED, then it could be clear-cut. But then again, it could not still be said who's right and who's wrong if this is not put into court. And that is would like to assure everybody that the AFP will, as I've said, will not be a hindrance to this. We would like to work with you based on the bill itself, on the law itself, the provisions, as a state party obligation to be able to undertake these procedures. And our collaborative efforts is primarily undertaken with, definitely with the Commission on Human Rights, because they are the independent constitutional body that is tasked to look into this. I use the term independent, primarily not constitutional body, but independent, is to give primacy to the being independent and be, so to speak, neutral on this matter, regardless of it is state or non-state actors. We agree that the crime of enforced disappearance is a crime only committed by state actors. We agree that the crime of torture, as provided for in Republic Act 9745 or the Anti-Torture Act of 2009, is also a crime committed by a state actor and not the non-state actors. That's fine with the armed forces of the Philippines. But then again, as we go back, it's always on the putting it in within the due process of law. I always use the anecdote, and pardon me if I do in this point in time. We don't like to have reports or incidents of enforced disappearance, and hopefully we will be able to work together and avoid this. Instead of the case, a case folder probably or information sheet, instead of this filed before a fiscal's office or the prosecutor's office, it's filed before ABS-CBN, GMA7, Philippine Inquirer, Daily Inquirer, or Philippine Star. I'm not saying it is bad. No, it is not. In fact, it helps out. But if this is filed in the media, there will be no court procedures that will be undergoing. So we would like to join now, especially with AFAD and FINE, to get jointly our information together. I don't mind if it's a member of the armed forces or a member of the Philippine National, as long as it's a state actor, we can join our hands together, make our information within the procedures, and file this in court. I'd like to pronounce during the welcome remarks, it was made mention regarding the fate of the matter regarding Shirley Cadapan and Caroline Peña, wherein these two UP students disappeared. Up to now, they're still disappeared. And one retired general from the Armed Forces of the Philippines is now indicted for the crime of, I think, kidnapping. But let me manifest this. When DOJ constituted, based on the report of CHR and upon the approval of the Supreme Court, when DOJ constituted the investigative panel under attorney, state prosecutor or state attorney Navera, we were there during all the days of the investigation. A AFP team headed by the Provost Marshal General, myself, a member of the Office of the Deputy Chief of Staff for Personnel, and a member of the Office of the Judge Advocate were there in the court or in the session wherein a preliminary investigation was being undertaken, not for the respondents, not for the complainants, but for the panel, so that we could assist them. And that led to the finding of a probable cause for the indictment of former General Palpara and two others. One of the soldiers, and three others. One of the soldiers who was just identified in that place during the session, we were the ones who provided the information to the court for him to be identified and eventually be indicted. This is what we can do and we want to do in partnership and in stakeholder engagement with all concerned, so that the law itself, the convention itself, may be implemented. And because of the study that we have, we are now in court. We would like now to, if I may borrow it from our office, to use it as one of our briefing materials in order to put the challenges. This is now a proactive measure on our part. so that when I go to the units on the ground, when I talk to battalion commanders, to company commanders, or even division commanders at the higher level, we now tell them what is the law, what are the provisions of the convention, and make them aware that there is going to be something done against them if they toy around with enforced disappearance. Again, it's a matter of putting responsibility over the shoulders of commanders. It is not an easy task. It is not going to be a task that will be accomplished in 2 days' time, in 3 days' time, or even a month's time. It's a continuing task. Because every period of time, there are new soldiers who are enlisted into the service. There are new officers, just like a few days ago when a couple of officers were commissioned as active, called to active duty and commissioned as second lieutenants. And we have to educate them on a continuing basis. Not only during the pre-entry courses, but also in the succeeding courses that they will have, basic, advanced, senior courses. And in this manner, really inculcate the culture of human rights, and especially the culture of the prevention of enforced disappearance. And we hope that this would be a contribution to this law, this bill that has been, as Congressman Lagman has been in Congress for a long, long time, that this would be a contribution that the armed forces of the Philippines could give in order to make sure that this can be undertaken and bring back the feeling of each and every Filipino that he or she is protected from the crime of enforced disappearance. And with this, sir, may I also, Congressman Lagman, sir, may I borrow also the matters that you have made mention so that we could also incorporate this in our briefings for our troops on the ground. We have been very active in information dissemination so that there will be no differences in interpretation of the law. The law has to be precise on the matter. Enforced disappearance must not be committed by any state actor. And we will support this, and we will get at those, whatever rank they are, whatever branch service that they are in, who perpetrate the acts of enforced disappearance. On the matter as far as the past cases, we are not turning our backs to them. In fact, what we are trying to undertake right now is to gather all the pieces of evidence, all the information, and probably request through the help of AFAD and FINE to be able to file this in court so that a just result can be made on these cases. With that, thank you very much, and may I congratulate the professor on the study that was made. Congratulations for a very beautiful and a very comprehensive study on the prospects and the challenges ahead. Thank you very much. Magandang hapon po sa inyo.
Thank you, General Tutan, for your reaction. Our third reactor is known to virtually all students of the UP College of Law and probably beyond. He is a known expert in constitutional law and public international law. He was a visiting professor in Harvard Law School in 2007, and he was a lecturer for the Hague Academy of International Law, and also a lecturer for the Philippine Judicial Academy. Please, let's all welcome Dr. Raul Pangalangan.
Congressman, good afternoon. General, and my colleague in the faculty. Professor Suna. Ladies and gentlemen, good afternoon. Just a procedural matter. Right after I speak, I'll just run out briefly because I wrote something for the Inquirer, and they're asking me to make some changes. So I'll just run out right after I speak. But I'll be back. Just 5 minutes. But, okay. As the only professor among the reactors, the reactors to Professor Sunga's presentation, allow me to indulge me in a broad historical view of this phenomenon. Why, in the first place, did this phenomenon emerge in the mid to late 1970s? both in Latin America and in the Philippines. If all they wanted was to get rid of someone, they can do exactly what they did to give recent examples in the Philippines, Doc Jerry, in Palawan. The standard procedure apparently was to have men in motorbikes, two men in motorbikes, the guy at the back doing the killing and getting the deed done swiftly. Why resort to the phenomenon of disappearances, which cause a different kind of pain upon the family and the loved ones of the victim? The pain of not knowing, the eternal anxiety, the failure to give closure, the failure to give a dignified burial to the victim. And my answer is that it actually has something to do with the law. It is the problem of attribution in the international law of state responsibility, the attribution to the state of the act, and also the breaking of the evidentiary chain. And that is why I'm so glad that Professor Sunga mentioned the Honduran case, Manfredo Velasquez Rodriguez versus Honduras, where the Inter-American court lowered the evidentiary requirement precisely because all that is at stake is state responsibility, not individual criminal responsibility. And that is why also if you look at the evolution of the terms in the Philippines by which to be referred to this, and Congressman, correct me if I'm wrong, eventually we devised the term salvaging to refer to disappearances. And I recall having to explain the Filipino English term for disappearances to a summer intern, a human rights intern from the US, and who ended up writing, he actually published an essay on how Filipinos evolved the term salvaging. But Congressman, if I recall right, before that we simply called it dukot. Dukot is the term for, how should I translate? So, dukot is to grab, to snatch, to grab, yes. And in fact, I recall I was a student activist then in the mid-70s, and we were talking about the most dangerous places in campus. And I suggested the most difficult place was the stretch of road, the dark stretch between the faculty center to Molave dormitory, to Kalayaan dormitory. Because I don't know if it's well lighted today, but it was completely unlighted 35 years ago when I was a student. And then if they wanted to dukot anyone in campus, that was a rather dangerous place. So if you look at the evolution of the rules, what we have is the failure of habeas corpus as the remedy. That was addressed by the Philippine Supreme Court in 2007. We adopted at that time, until then, the Latin American writ of amparo. We adopted into Philippine law the writ of amparo. Foreign experts say that it is a uniquely Philippine adaptation, quite different from the original amparo, precisely to fill in the loopholes of habeas corpus. Because habeas corpus, if the remedy sought is the writ of habeas corpus, it is satisfied as soon as the authorities say, we don't have him in our custody. And that's the end of the story. How can you force them to produce the body if in the first place they never had him in their custody? The writ of amparo was supposed to have solved that. The writ would impose an additional burden to explain why that person is not in their custody and to enable the family, the petitioners, to identify potential places where the victim might be held in custody and to authorize the court to find that person. But that was in 2007. We are now 5 years beyond that. And I have in fact suggested to the Philippine Judicial Academy to evaluate the record of the writ of amparo, because apparently it's not working the way it is designed to. And that in fact the remedy provided has not been equal to this phenomenon of the desaparecidos, of the disappeared. And that is why after the writ of amparo, the Philippine Supreme Court adopted the writ of habeas data to compel not the production of the body, but the production of information, so that we will be able to trace the victim. And that is why we go back to the Alston report. Philip Alston, the UN Special Rapporteur on extrajudicial killings and enforced disappearances, who spoke of, and here I quote, a passivity bordering on abdication of responsibility. This was before the time of General Tutaan. And I say this because I have sat down with General Tutaan in a previous occasion, and I have heard the program of General Tutaan to make sure that this doesn't happen again. But the Alston report shows the difficulty of government offices simply looking the other way, which brings us then to the convention reported to us by Professor Su. I think, Bombi, we should distinguish between the problems faced by the victims in the past and the task of preventing it from happening again. And I think in making that distinction, we must confront the threshold problem of attribution. I don't think we have found a solution to that problem, Monty, because notice that what was achieved in the Inter-American case on Manfredo Velasquez Rodriguez was merely to establish attribution to the state. We have not gone down to the level of defining what the state ought to do as soon as attribution is established. How it is going to, in other words, to identify the remedies available to the victim. The Rome Statute, for instance, which we have signed, the Rome Statute. The Rome Statute will include as part of restitution for the victim purely the information on where the body is buried is itself part of the remedy. I do not know to what extent we are able to address that difficulty. In other words, speaking as a professor, and I would like to close on this point, in Philippine law we have experimented with rather creative remedies for this phenomenon of enforced disappearances. We have devised the writ of amparo and the writ of habeas data. We have passed the law, the IHL law criminalizing this act. But I think, especially for the writ of amparo, the failing is a failing of appreciation. In fact, I recall one line from the Court of Appeals in the case of Jonas Burgos, where the court says, we must be careful here because what is at stake is the professional reputation of the general involved in that case. But it struck me, this is a mere administrative case. We are not accusing anyone. We are not about to punish anyone for the disappearance. The writ of amparo was there purely to find the victim. And yet the court misconstrued the remedy and saw it almost as if it were a criminal case pending against a ranking officer. For me, the convention is a step forward. I recognize that. But I think the convention should merely set the stage for more specific remedies that the writ of amparo and the writ of habeas data tried to achieve. And today, 5 years thereafter, still have failed to do. Thank you very much.
Thank you for your reaction, Dean Pangalangan. He was my professor in constitutional law way back in first year. Alright, our fourth reactor is a family member, was a sister of the first documented Filipino desaparecido, Charlie Del Rosario. Let's all welcome Miss Teresita Del Rosario.
Magandang hapon po sa ating lahat. Desaparecidos. Yan ang tawag sa kanila. Mga nawawala. Missing. My brother Charlie Del Rosario went missing on March 1971. Maybe on the grounds of PUP or in the vicinity of Recto Avenue. He was the first documented pre-martial law desaparecido. No words can describe our pain, the anguish since the time we missed him. We waited 41 years for him to show up. He was only 27 years old at that time. He was too young to deserve such treatment. Nasaan si Kuya? The question still lingers. Sa mahigit na 41 years ng paghahanap, ni bakas ni Kuya Charlie ay hindi na silayan. My brother was the first documented disappeared, and we have to stop the growing number. The policy paper prepared by the UP Institute of Human Rights is another leap in search for justice for the desaparecidos and their families. Justice has been a long outcry of the families since martial law. The paper exhibited a clear description of enforced disappearance and its effect to the victims' families. And I witnessed how my family mourned over my brother's disappearance, and I dare to say that the crime is really very cruel in its highest form. Based on the reports presented, there are only 638 out of 3,009 cases that have been disposed. The remaining cases are still outstanding. Let us be reminded that behind these 2,371 outstanding cases, there are families groping in the dark with anguish in their hearts, hoping that their missing loved ones be returned to them, dead or alive. The number of desaparecidos during martial law has reached hundreds. But what is more bothering is that there are still victims at this point in time. No more martial law, no more Marcos regime, but the abuse had been passed from one administration to the other. What is more upsetting is that there are no definite law that punish such horrible act. This policy paper indicates that what was lacking and what is needed to stop the enforced disappearances. It has proved the ineffectivity of the writ of habeas corpus, the writ of amparo, the writ of habeas data in defining the gravity of the offense, tracking and bringing before the courts the victims and their perpetrators. I think this paper has a good basis to rethink and review the rule on the writ of amparo, the rule on the writ of habeas corpus, the writ of habeas data, a solution for the growing predicament, and as a starting point in the creation of a real penalizing enforced disappearance. As reported, the Philippines is not yet a party to the Convention for the Protection of All Persons from Enforced Disappearances. However, it should be noted that in adherence to the international law, the Philippines, even if it's not a partisan of the convention, is obliged to respect, protect, and fulfill the rights of its citizens, and not to be a victim of enforced disappearance. Nevertheless, what was presented in the paper will serve as a starting point, a basis to pass the needed bills in favor of the victims of enforced disappearance. According to Human Rights Watch, the Aquino administrator has not yet successfully prosecuted a single case of enforced disappearance. He promised that he will penalize any forces responsible for the serious abuses. However, as emphasized by Ms. Elaine Pearson, Deputy Asia Director of Human Rights Watch, concrete measures rather than more promises are needed now. Accordingly, what was written in this paper should be taken into account. We have to act it out now. Use it where it is intended to. May this policy paper reach His Excellency, our President, for this paper summarizes the plea of the families of the disappeared. Hindi ko man makikita muli ang aking kapatid. Ayokong danasin ng iba ang bigating sinapit namin. Naway maging simula ito ng pagbabago at sana'y sama-sama nating pigilan ang pangaaping naranasan. Sabi nga ni ilang-ilang Kihanon tungkol sa biglang kawalan. Puntod nila'y itinayo sa puso ng mga naninindigan. Ipagpatuloy ang kanilang sinimulan. Maraming salamat po at magandang hapon.
Thank you very much, Ms. Glenn Rosario. Our last reactor, this one came from the media. She is a senior writer of SciDev.net. She's the editor of School Watch Journal, and the former senior desk editor of the Manila Times. She is also one of the 10 journalists cited in the 2007 Jaime V. Ongpin Awards for Excellence in Journalism. Let's all welcome Ms. Nora Gamulo.
Magandang hapon po sa ating lahat. I was in my late teens and a political science student of the University of the Philippines in the late 70s when I first became aware of and started writing about enforced disappearances. At the time, I was a young campus journalist. I wrote about it, no? As a mainstream political writer, starting from Malayawi Forum in the mid-1980s to the Manila Times just a few years ago, where I was senior desk editor, development columnist, and coordinator of special reports, many reports of which dealt about human rights violations in the country. Since then, I have graduated into becoming a science writer, a very, I should say, napakakalmanting area of journalism. And I also work as editor of academic journals. Actually, my main source of income is to edit and write materials for academic journals for children in basic education. And human rights, I assure you, is one of the areas that are normally put in dun sa aming social studies journals. Just the same, the problem of human rights violations, including enforced disappearances, has obviously persisted even more than 3 decades after I first wrote about it. No, in fact, I have to confess that nawala sa radar ko itong International Day of the Disappeared din po. And it was only upon receiving the invitation from Find and Afad that I got to remind myself. And of course, as I write this reflection, naalala ko bigla, ang tanda-tanda ko na pala. Part na siya ng personal context ko, writing about human rights violations and enforced disappearances for the past 30 years, or more than 30 years. And for me, there's really no question about it. Something is definitely very wrong in a society where problems of this nature continue to thrive, not just to persist, but to thrive. No? Even decades after, in fact, after almost half a century after they first became manifest. I am impressed by the wealth of hearts and minds that went into attempts to resolve the problem of human rights violations in the country, including enforced disappearances. And thank you, Institute of Human Rights, no, for your assertions that, okay, in quote, enforced disappearances are generally carried out by specialized units that make up highly secret bodies within the armed or security forces. Okay, second assertion. Disappeared persons are generally political opponents and members of grassroots organizations who, as a consequence of the enforced disappearance, became subject to the whim of their captors. So sorry po, General Tutaan. No, all these assertions have actually come through several layers of validation. First, these are assertions made by activists, studied by academicians, okay, lawyers, and eventually validated by media practitioners, even without going through very serious standards of evidence that is actually the law. No? I mean, that's really part of the context of the law. Okay, you know, regardless of how lawyers would assert it, no? Nandun yung public perception, validated by experiences, not just by Filipinos, but by experiences of other people, of other nationalities. I joined, actually bawal sa mga journalists na to confess their biases, but let me make an exception in this case. I didn't just report on human rights violations. No? When you feel the pain of people who have suffered unduly, it gets into you. And so I, as a citizen and as a journalist, actually joined the human rights community in asserting that the Philippine government, as a first step, ratified the International Convention for the Protection of All Persons from Enforced Disappearance, and for the Senate to give its concurrence. sana hindi siya maging deathbed nitong bill na katulad ng sinasabi ni Representative Lagman. Now, these actions will be symbolic and substantial proof that is really committed to end enforce disappearances. Okay. Indeed, aside from ratifying the convention, the government should seriously consider large-scale and sustained efforts to strengthen the justice system in the Philippines, to check against the possibility that state forces will engage in enforced disappearances and other human rights violations. So sorry, apparently the ball is really on the other court. Kailangan may strengthen ng justice system and ensure na wala ng human rights violation here that will magmamanifest sa ating bansa. We take note, however, that enforced disappearances are only possible in a country with a highly threatened justice system. The government is challenged to ensure that existing laws that uphold human rights be enforced and reforms in the justice system adopted and implemented to deter continued human rights violations. And in this arena, it seems the road is long, winding, and full of thorns. Mahaba pa po ang ating lalakbayin. And, as a journalist, let me say this. In the process of going about this campaign, this commitment, it seems we're really going to, as has been proven, from the 1970s to 1986 when we had the ESO Revolution, we are still going to witness continuing cases of human rights violations. It is not prejudging it. It's really looking at the road we have gone through. This is past experience. There is nothing, apparently very little, that will give us an assurance that all these cases will not happen again. So, but even if the convention is not yet approved, the people have the right to demand certain things from the state. Okay, and may I share with you some reflection based on my experiences interviewing the families of the victims of enforced disappearances and other human rights violations. Okay, first, we can actually demand. It is our right, no? And a series of governments from 1986 to the present have actually promised full-scale investigation of and the cooperation of state forces in the investigation of cases of enforced disappearances and other human rights violations. Hopefully, actually, I'm sure they would, no? Media, civil society, and other entities will keep watch with us. But sir, by the way, General Tutan, if I also can say something, I think one of the requirements of this is for state forces to really, conduct genuine full-scale investigations, regardless on where the sword will fall, no? Okay? At sa naman, hindi naman protektahan yung mga, because in many instances, these perpetrators of enforced disappearances and human rights violations have been identified. But wala namang, in fact, halimbawa sa case ni Jonas Burgos, no? Isa sa mga demands nun was, kasi nagsabi na karoon daw ng mga investigation, wala naman po akong narinig na I haven't heard of any internal document of any investigation concerning any investigation conducted by the AFP. Presumably there were some investigations, but they apparently weren't made public. Parang the general sentiments of the investigators were shared. Pero wala yung actual documentation that speaks of how the crime progressed, how it was hatched, how it was executed, and what happened to the victim. So that is exactly the kind of full-scale investigation that people are expecting. Oh, and by the way, if since you raised this kanina, may I say that whenever the families of the victims do come to the media, I am sure that they also come. It's not just the media that they go to, but they also go to many different channels to seek assistance, no? to find out exactly what happened to their kin. So it's not as if they just went to the media. So, and also the media is not a court. I mean, it's not a legal system. We do not have rules of evidence or anything except that reasonable documentary evidence, a credible witness, yung mga ganun po. I mean, we do not go through yung very, very rigid standards of evidence that lawyers have to establish. Okay? Because ang isang malaking, magkaiba po kasi yata talaga ang parameters ng mga lawyers at saka ng mga media practitioners. Perception is a very, very important factor in journalism. Even if you do have one witness, if this is a credible witness, or if this witness has a personality to say about something, then it will go. I mean, the report will go. And then, okay, so let's say that's for one day or for one half day. And then if there are some reactions later, that will be another report. No? I mean, so, okay, so there's just going to be an exchange of reports. I mean, that is how media practitioners operate. And I hope that the Philippine society has benefited largely from that kind of reporting system, in the sense that it also ensures a faster way of transmitting the news. If there are other people who would like to counter the news, then that's an entirely different thing. And media will, of course, be obliged to present their case before newspapers, TV, radio, TV, and even the online news. Okay, so another point is that since after 1986, there was actually a boom of retraining and reorientation activities for state forces to make them aware of human rights, both as a social standard and as a social good. These activities were backed up, actually, by a slew of laws, many administrative in nature. Actually, with very, very strong disciplinary norms. So maybe this is a challenge for all of us, and especially for the officials, of the state forces. Maybe it is time to revisit how these laws have been implemented and discover what had been lacking in their implementation. Actually, this was particularly a campaign participated in not just by the police, by the military, sila ang nasa receiving end. But I do know of many civil society groups, even academicians, even media practitioners who were part of these training activities. Okay? But some weaknesses apparently manifested along the way. So it's now time for us to discover what had been lacking in the implementation of these programs. Hopefully, we could patch up some holes, but again, of course, and we are very much aware of this, but only when the state forces recognize that civilian power actually reigns supreme over military rule. Now, civil society groups that assist bereaved families and families of alleged victims of enforced disappearances deserve to be given support too, so they can continue this kind of social action. Maybe it is high time that we demand a state fund for all victims of human rights violations that is not contingent on the distribution of the Marcos billions, but funded from current and existing state funds. And speaking of the Marcos billions, I received a text yesterday or the other day that the Marcos money that has been deposited in Philippine Veterans Bank, supposedly amounting to hundreds of millions of pesos, the funds have been reduced to only 1 million. So if you're going, if you're going to make a support for human rights victims contingent on the recovery of the Marcos millions, when are we going to realize that? Baka next time, probably let's say in a month or in the next year, we just might discover na, there's not even $1 million left among the Marcos billions to be given to human rights victims. And of course, I think under the law, you still have to share the Marcos billions with agrarian reform beneficiaries, which is an entirely different program. Okay. Now, unlike you, I am not sure how to end or what could be done, or if there's any single formula that could allow us to end enforced disappearances and other forms of human rights violations. Because actually the requirement is a massive and comprehensive social transformation that I presume all of you will agree with me is not lurking in the corner. So maybe after a century. Okay? It's probably not going to come about anytime soon. However, we are challenged to dream and to act accordingly so our dreams can come true. After all, dreaming is one thing that distinguishes humans from other creatures of instinct. Unlike dogs, cats, or other animals, we actually have the capacity to choose, to bear the burdens, to accept, to do something, so we could resolve the burdens imposed on us by history. So, hopefully, onward ang ating direksyon, and towards the direction of fewer, if not zero, human rights violations. Marami pong salamat.
Thank you, Ms. Gamolo. And now to facilitate the open forum, we have Mr. Jose Marie T. Faustino, Secretary General of FIND.
Magandang hapon po sa ating lahat. Salamat, Diana. Marami na po tayong narinig ngayong araw mula po sa ating congressman who showed us what it is like na ipaglaban ang enforced disappearance sa ating kongreso. Narinig na din po natin ang ating presenter sa pangangailangan ng international convention. So, at ang ating pong panel, no, na marami na rin pong na-share sa atin. So, malamang po ay marami na rin po tayong iniisip na katanungan. Ito na ho ang pagkakataon naman na tayo sa mga organizations at sa mga nandito, those who are with us here can now ask questions if you'd like to clarify. Just to tinker your minds a little bit, you always would wonder why it would be so difficult for any government to say that we will not practice, we will not tolerate enforced disappearance. Now it requires a paper by the UP Institute for Human Rights just to push for such a convention to be ratified by government. Then you would also wonder, how many General Tutaans do we have in the AFP? Or do we have more of the General Palparans? See? That we do not know. So please try and formulate your questions now, and we will entertain them in the next few minutes. However, I would like to start out with a question by Attorney Byron a while ago, and I think that deserves a response from our distinguished Congressman Ed Salaman.
Thank you, Joey. I have some reactions to some of the reactors. Well, my good friend Byron has again resurrected the issue on whether non-state actors should be included in offenses which are principally against the agents of the state, because these offenses are traditionally and invariably committed by the state to its agents. I think the definition of enforced disappearance under the convention is clear, complete, and unequivocal. Pinning liability on state actors or agents of the state. And Article 3 does not extend that definition to non-state actors. Or that Article 3 would like to say, just because non-state actors are not included in the definition, the state should not do anything anymore. It must. It should investigate, and once the investigation is completed, if prosecution is needed, then these non-state actors or perpetrators should be prosecuted under existing penal laws, but not under enforced disappearance once enacted into law. And this issue has been raised when we were having the bicameral conference committee on the anti-torture law. Because some of the companies wanted to include or ensnare non-state actors as liable under the torture law. And I was there because I was the principal author of the bill in the House, which became the anti-torture law. And the bicameral conference committee resolved this issue by not including non-state actors as perpetrators of torture, traditionally and invariably committed by the state or agents of the state. They can be prosecuted under other penal laws. Now, we would like to congratulate Brigadier General Tutaan for being an enduring partner of human rights groups like FINE and APAD. It's probably because of this partnership, FINE and APAD referred to him 19 or 18 case holders of enforced disappearances. And it's very possible has already gone over this and possibly also found that there is a credible case against the alleged culprits. And under existing law, there is the revised penal code or the anti-torture law, where cases can be filed pending the enactment of the enforced disappearance law. And all of these are public offenses. In other words, any party can be a complainant before the prosecutor's office or the courts. And I hope that the armed forces of the Philippines, through the Human Rights Affairs Office of the Armed Forces of the Philippines, can initiate cases as a complainant, because these are public offenses. And lastly, to my good friend Dean Pagalangan, I think salvaging is not equivalent to enforced disappearance, because salvaging refers to extrajudicial hearings. It does not include the element of concealment of the whereabouts of the victim. And salvaging still continues up to today, just what is being done in Davao. So, and in the case of salvaging, the salvaged victims are found. They're just littered in many places, but it is so unlike the victims of enforced disappearance. So thank you so much, Joey, for giving this opportunity to react to the actors. And lastly, Nora, I don't think we have to wait for a century to end enforced disappearances.
Yes, we have good news that we can probably have it by 2012. The next thing is what General Tutaan said. Now it will be time to file the cases. But today and this time, it's still time to ask your questions. So, yes, please. Please use the mic, identify yourself and your organization. Thank you.
Magandang hapon po. Rebecca Lozada ng Philippine Coalition for the International Criminal Court. Two things. That came to mind while everyone was talking, and thank you very much for the presentation. What our actor talked about the impunity gap, two things came to mind. One was highlighted to me because of what General Putaan said, and I was pleasantly surprised that he said they will accept all these definitions that puts the responsibility to state parties. At the same time, you are a military and I'm a civilian. So from a civilian point of view, whoever commits that crime, I think, is of concern to us. And with all due respect to what our beloved Representative Lagman said, I was thinking that since this law is not yet enacted in the Philippines, I'm hoping that some of this particular issue can still be addressed. Because, well, of course, we as part of the PCICC, we advocate for supporting the court and the ratification of that Rome Statute. At the same time, now we are dealing with some of the weaknesses of the Philippine IHL law, including, to my mind, I mean, this is not like a consensus yet, but to my mind, including parts of how to enforce it in light of weaknesses to our justice system, in the very high standards that is reflected in the IHL Philippine law, because it is adopted from the Rome Statute. Very high standards like how we define crime of aggression. Because it was defined for the use of an international tribunal, it says, you know, the crime has to be committed in a widespread and systematic manner. But in other national laws, it can also be just widespread or systematic. We put it in a very high standard, I think. And I think now we have to deal with the fact that, you know, there are crimes like this, and if we put that very high standard, then the law, there will still be a gap in the Philippine law. So I'm thinking, I was hoping that there will be still some opening here on how to address political organizations who commit this crime. I will leave it at that. I know this is a point of debate even among the communities advocating for a convention on the enforced disappearance, but I think it's a very real issue. Because even though probably most of the crimes like this are committed by state parties, we know for a fact that there are non-state actors political organizations who do the same thing. The second is more of a question. How does the Philippine law address the weaknesses in our justice system? The Rome Statute, the Anti-Torture Act, they have been around since 2009. And it's true what the General said that no one is bringing cases. And then when you go to the ground, people are saying, we cannot bring cases because how can we trust in a justice system where witnesses are, you know, getting killed and all these things. So what are the steps or what do you envision are ways to address the weaknesses in the justice system?
Are you addressing your question to the good congressman?
Or
any?
Maybe even the advocates will have some answers.
Anyone from our guests would like to respond to the question? General Totaan has something to say.
Just to say something about it, in totality of the matters raised by Ma'am Becky and Lozada, and of course on the I think with yet the bill to be promulgated into law, I think what is better to be looked into is Section 4B of Republic Act 1951. Republic Act 1951, or Section 4B, specifically states about war crimes in a non-international armed conflict setting. Wherein it already specifies there's so many things. Willful attacks on civilians, willful attacks on non-military targets, taking of hostages, things like that. It could be a complementary provision of law that can be used to complement probably other provisions of law that will be used. We could probably use, just thinking aloud on the matter, we could probably use the anti-kidnapping law or arbitrary detention law compounded with violation of Section 4A, Section 4B, I think paragraph 3, which is taking of hostages, to make sure that this is in effect. While the anti-enforced disappearance bill is not yet enforced into law as far as this is concerned. And I think the reason, the other thing that Ma'am Becky was saying about judicial, that is the reason. Let's join hands together in doing this. If we have a full-blown investigation wherein all parts are there, we could use this in fighting the case. The problem is, as mentioned, just like what was Ma'am Nora was saying, if there are differences, I've been emphasizing that in what has been investigated. Not to be an apologist for the AFP, not in defense of the AFP, but when two things are different, who decides on it? It's the court. So let's bring it to court. And that's the reason why I'm saying, how many of these cases have been placed to court? Of course, there are other things on the side collaterally to the problem, like witnesses don't like to come out in the open, or victims don't want to file any more charges in court and things like that, and so on and so forth. That's why it's a collaborative effort. We will be of partnership to everybody. We, the security forces, I think I could speak for the AFP as well as this, to collaborate in coming out with something that we can file in court. Because again, Rule 110 would say no case will commence if there is no case filed in court. True, that's true. Nobody has been prosecuted. That is true. Yeah. But how many of the cases being referred to have been placed brought to court? If you will count, with all due respect, I think the 18 cases that I have, 17 cases, sir, resulting to 18 victims. None of them have been filed in court. So that's what I'm trying to do right now. So that if there is, yes, so if there is, we could now file it jointly to file in court, so that we could be able to get into the perpetrators of these crimes.
Yes. Yes. Well, in reply to the query of Rebecca, let me make a motherhood statement, because grandmothers, like mothers, know best. You know, I think the executive must be able to fully implement and enforce the law. The prosecutors must prosecute and seek conviction without fear or favor. And the judiciary, the courts, must resolve cases expeditiously. And I think that that's one way of reforming the justice system. And talking about a full implementation of the law, I would like to remind the CHR, Commission on Human Rights, to my good friend, Attorney Byron. I think you have to remind ETA that in the anti-torture law, there is a provision creating an oversight committee to monitor the implementation of the law. I have asked ETA a year ago to make representations with the leadership of the House and of the Senate to constitute the committee, because the committee is chaired by the chairman of the Human Rights Commission. That's one thing where we have lapses in the implementation of the law.
Hopefully, by the next time we gather around is for the implementation of videos. There's a gentleman who first raised his hand, then we'll have the lady at the back.
From the DOJ.
Sorry, the mic is quite short for you. Please manage.
I'd like to react on statement earlier that since the time of the president, no conviction yet has been done for enforced disappearances.
Excuse me, can we have your name and
I'm
your
Rafael Villanueva from the Department of Justice. And that is exactly the point. You know, wala akong conviction, wala akong prosecution dahil wala akong batas. When I was talking to prosecutors actually yesterday, how many enforced disappearances do we have? How many EJKs do we have? How many, you know, all these crimes? Wala ko silang masabi dahil wala akong batas na nag-define ng enforced disappearance. Of course, they can always prosecute for kidnapping or serious illegal detention, but as an illustration, if you can turn your attention to those circles over there, over that side, you have the yellow circle and the red circle. I would liken that to the current situation. Although enforced disappearance and kidnapping share certain traits, certain elements, they do not coincide. So, yun po yung gap na nakikita namin. We have conventions, ICCPR, and of course, let's see if CITOPED will be ratified. But until we have a law punishing enforced disappearance, then we cannot fully implement and we cannot fully fulfill our obligations to those international treaties. But that doesn't mean that DOJ is complacent. DOJ is not doing anything. Tama po yung sinabi nila Byron, nila General Tutaan. You know, there are other ways.
for now.
For now. And plugging the gap by a law is not the end-all and be-all solution. It's not the only solution, it's not the complete solution. It should involve everybody, the media, the civil society organizations. With DOJ, one of our recent undertakings is we partner up with the CHR and the UPIAJ, the UP Institute for the Administration of Justice, and we are coming up with a revised prosecutor's guidebook for human rights violation cases. And that aims, we entered into a MOA, which aims to well, make it more efficient, the cooperative mechanisms between CHR and the DOJ. So, yun po yung update ko. But I have a question for the panelists. Nowhere in the elements stated in enforced disappearance, I'm wondering if motive is to be considered in saying whether an act is an enforced disappearance or not. Is it important in determining whether an act is enforced disappearance or not?
Attorney Bongi?
The convention itself is very clear on the elements, and the elements are those three flashed on the screen a while ago, and they do not include a motive. It's very hard actually to tell what a person's motive is, and what a person's motive is something that's internal and it's expressed in the actions of the person. And when we look at the actions of the person, the elements are limited to those three. The studies cited by our paper show that frequently the motives of enforced disappearances are to threaten and to sow fear in the hearts of those who disagree with the government. However, while the literature shows that this is often the motive, there is no element in the definition that pertains to the motive.
I'm just concerned because and this is also our problem with extrajudicial killings. If, for example, a government official abducts another person for personal motives, then it's possible that he can still be indicted for enforced disappearance, because in those three elements, motive is not important. That's one problem that I'm grappling with.
Well, that makes your job as prosecutor even easier. As long as you find yourself to be the division of the offense, then so be it. But as lawyers, we know that there's a difference between the offenses punishment under the revised penal code, which is law, and special laws. You know what I mean. Thank you.
We have something from Dr. Raul.
I don't see that as a problem, because even if his motive is for private reasons, personal or family reasons, the important thing is that he's a state agent. He has access to the power, to the network of government officials, and that does figure in the carrying of the offense. And I agree with the Congressman. A special law. So let's wait.
Yes, as well as I think part of the security sector, the AFP being an arms bearer, I think the motive of this is immaterial. Since I am a soldier, I have, so to speak, an authority, because I am an arms bearer. I couldn't use that just to grab anybody and keep that should not be a reason for me to do it. So the motive on ED, I don't think for us arms bearer. But the thing is that again, emphasizing Article 1 and 2, we have to abide with that. We cannot just grab anybody and put him solitude or whatever because of some whatever, if it's personal or not. We are arms bearer, we should not do that.
Thank you. Then we have the lady of the back, please.
From the Institute of Human Rights. So far we've been talking about accountability and we're discussing the elements of crimes, how we bring the perpetrators sa mga korte. But I'm just toying with the idea that we expand the concept of accountability from purely legal accountability to perhaps talking about democratic accountability, which would highlight more of yung tinatawag natin institutional responsibility. Kasi mukhang normally we zero in on the individual and then the superior, and then alam naman natin yung obstacles to gathering evidence and then bringing the perpetrators before the court. I'm sure yung concept po kasi ng democratic accountability is wider, no, than just purely legal accountability. And minsan nga ho, na i-stamp tayo dun sa usapin na dalhin sa korte. Siguro ang mas appropriate question would be, ano na ho ang ginagawa ng AFP with respect to the issue of enforced disappearances, past and present, no? Insofar as investigation, ilan na ho ang na-investigate, siguro it's really more into knowing what has a particular stakeholder agency, government agency, has done insofar as that issue is concerned. So pasuko tayo sa usapin ng lahat ng actors in justice system, like the DOJ, the courts, no, kung paano nagtutulungan. Pero in particular, kasi nga ho, based on existing data, ay ang AFP, mukhang sa AFP nagmumula yung dating mga perpetrators. siguro baka pwede natin tignan din yung usapin na baka pwede natin we come up with standards and parameters of democratic accountability, which is I believe no not limited to bringing the perpetrators before the court. So baka pwedeng malaman din from the AFP kung ano na nagawa, and then baka pwede mo nating sabihin kung kulang pa ba yan. Mukhang given mo the reactions, mukhang may kakulangan pa rin mo in that respect.
General Tutaan, she would like to know kung ano na yung nagawa so far.
I wouldn't claim that there's a lot been done. That everything has been done. It's a process that we're undertaking. The thing is, if there's going to be democratic accountability, let us also be enlightened with a provision of constitution of equal protection of law. If I may say so, that this is in behalf of the soldiers also on the ground who are falsely accused also as a matter of propaganda. Yung mga sinasabi ko po is not specific on persons. Mga sinasabi ko po yung two men riding in a motorcycle believed to be soldiers. Ano po yung, saan po nangyari? It happened in, let's say, Bulacan. Two men riding. Anong unit ang nasa Bulacan? It's XX battalion. So the report becomes, two men riding in a motorcycle, members of the military believed to be from XX battalion. Sinong head ng XX battalion? Si Lieutenant Colonel Juan de la Cruz. Two men riding a motorcycle believed to be soldiers from XX battalion led by Lieutenant Colonel Juan de la Cruz. Lieutenant Juan de la Cruz now goes to CHR. And his clearance is modified. And he has no way, Lieutenant de la Cruz is gone. Those are the things that are the extremes. I'm not talking about specifics na may suspect talaga by names and everything. And these matters we have investigated. I have investigated, although this is a crime of torture, we have conducted investigation. Everything is there. We have already done on the administrative sanctions as far as military justice system is concerned. But the case cannot be prosecuted. Ayaw kasi ng victim mag-file ng case sa court. We were trying to convince him. Then we were able to resolve that the victim filed with CHR. So parang kung namin CHR sana maayos na para they can send it to DOJ can immediately para ma-prosecute because we know already who they were. And we admitted that already. We already pronounced that. Inaantay lang namin, hindi namin sila mapadala sa jail because hindi naman kami nagsisentence ng tao. It's still the court procedures. But so it's a tedious process also. So hindi ko naman sinasabi wala kaming ginagawa. Or I would say, para nga yung sabi mo, is this a half-empty glass-filled water? Or is a half-empty or half-filled? Siguro masagot ko lang sa iyo, ma'am, is that thank God there's a glass. We're doing something about it. Thank you very much, ma'am.
Okay, thank you. Now we have to have the last question, please. Yes.
Magandang hapon po sa lahat. Siguro kailangan kong sabihin saan po ako nagagaling. Ako po si Daisy Valerio. Nag-abra po. Pero ako rin po ay dating Secretary General ng FINE for 6 years. 1995 to 2001. Kaya matagal kami magkakasama ni na Kuya Edsel, Ate Nils, at iba pa. Maraming nandito. Dito sa usaping ito, pasensya na kung medyo natipikon ako pag pinag-uusapan masyado ang legalities. Kaya minsan, para mapagaan ang aking pakiramdam, dinukot ko na lang si John Lennon. Kaya lang, mukhang sa pagkukot ko kay John Lennon, ay nakusunadahan siya ng mga gustong pumatay. Alam mo siguro, na-idea kayo kung sino siguro. Ang sinabi ni John Lennon, I don't understand the law because it is finite. Of course, I understand, I appreciate everybody's contribution. The legal community, everybody is my brother. I consider everybody as my brother. And that every woman has a contribution, and every child and every mother, grandmother has a contribution to this cause. Of course, I will never forget Mommy. Mommy Lagman. I am very sorry I was not there. I know she must have been looking for me as Niels told me. But nature came between us and it was sobrang baha. And my foot was so swollen, so I cannot walk properly. But I have a remembrance from Mommy. This golden watch is from her. Niels, I showed it to you already before. I didn't want to accept it from her because I'm not used to using golden things. My parents used to give me, they kept earrings, golden earrings for me, but I never accepted it. Gave them to my sisters. First and foremost, I'm also the wife of Nilo Valerio, a desaparecido in 1985. He disappeared on August 24, 1985, and we had 3 children who were 3 and 4 years old at that time, and who kept on waiting for their father to come home. And my children at that time never understood what death meant. My 3-year-old son, Jerry, drank to his father so many times, talking to him, crying at the middle of the night, although they are not crybabies. They were never crybabies. Our children were never crybabies. They could take care of themselves even if I was going away from them. My mother was there, my mother-in-law was there, all our in-laws were very supportive of us. But anyway, I'll go back to the finite space.
Yes, please. Kindly go to the question.
Anyway, what I just want to say is this. When I became Secretary General of Fine in 1995, we were already bogged down with the legalities. So the law, the proposed bill, never came up as a law. And during sessions, there were many officers of the government. I was active very much at the Quezon City Hall. At that time, when my older son was lingering in the hospital, in the Liver Hospital in Project 4, when that police officer was saying, maybe your husband went away with another woman. My goodness, I wanted to slap him on the face right then and there. To think he knew better than us, who are the ones. My husband never looked at any other woman when we came out, when we started to have relationships. We were working together in Abra for so many years before we got married as a revolutionary movement. So nobody can tell me that. Please! Somebody walked out on me when I was talking at Quezon City Hall. Niels was there and many others were there. Please be careful. I only request our brothers in the military, and also we are tired of all the legalities and of all the pasakit. I'm speaking not only for myself, but for the other. I'm speaking in English because I know this will be televised, and I'm not afraid to speak up before anybody. And please, my only boss is God. I don't belong to any boss. My only boss is God. So don't owe me anyone. So what I'm saying again, I'm going back. Please, let us not deal so much anymore on the legalities, on whatever things that we keep on speaking so that the law, our own law, will not be passed again in this session. I monitor everything on the TV, wherever I am, TV, radio, internet, whatever. And still the same thing that I hear. Hindi tayo pareho sa ganito, hindi tayo pareho sa ganito, may problema sa ganito. Napakaraming problema sa daigdig. Namamatayan na tayo napakaraming ulit. Jesse, nawala. Ano ibig sabihin dito? Lahat ba nito? All the good people are dying, and yet we're still speaking about all kinds of things. All legalities.
Madam, I have to ask you to finish, please.
Okay, thank you very much.
Thank
That's
you.
all that I would like to say.
Salamat po. Just a reminder. Okay, so now back to Marie and Diana. We're ending the open forum. Thank you.
thank you for all your questions and to everyone who shared their experiences. That was quite an interesting discussion. And now to synthesize all that we have been discussing this afternoon, let's call on Attorney Milagros Isabel Cristobal from the Office of the Chairperson of the Commission of Human Rights.
Good afternoon, everybody. At the end of a very interesting forum like this comes the easy task of trying to summarize what everybody has contributed to the discussion, and that is not quite easy at this point. But allow me to do my best. We started the afternoon with our guest speaker, Congressman Lacman, who has in fact pointed out that the efforts of Congress insofar as passing the enforced disappearance bill has taken quite a long time. The efforts started way back 20 years ago with the participation of several NGOs, in fact. And he has pointed out that, the campaign for enforced disappearances actually interlocks with the struggle for peace, justice, and democracy, national sovereignty. And this is something that is essential in the context of the problem of enforced disappearances. The first bill, which was ever introduced, was not given full-hearted support simply because it proposed the death penalty for the perpetrators. And true to the human rights advocacy of the organizations refused to support it until a second bill was then introduced, and which revised the proposed penalty to reclusion perpetua, and from then on, the continuing struggle of the different organizations, civil society, and some government and our friends in Congress continued. The efforts of civil society was not limited to working for the passage of a law, local law on enforced disappearances. In fact, the interventions went insofar as even contributing to both international and fora in terms of passing even the Convention on Enforced Disappearances. After the congressman presented that, we had a speaker, Attorney Bombisunga, who presented to us a paper that examined the very nature of the offense of enforced disappearances and the importance of the International Convention for the Protection of persons from all forms of enforced disappearances. The question of whether the government should ratify it was discussed. The nature of the violation was presented, including the common elements in the definition of enforced disappearance, which of course centered on three: the involvement of government officials, the deprivation of liberty, and the refusal of government to acknowledge the deprivation of liberty or the concealment of the person who has disappeared. Also has emphasized that enforced disappearance is actually one of the cruelest, if not the cruelest form of human rights violation because of its depth and complexity. The victim is not just the victim who has disappeared, but even the family members who have been left behind. As has been pointed out, these are victims. The victims of enforced disappearances have still no place among the dead, nor do they have a place among the living. They are in what we would probably call limbo until such a time that the truth to their disappearance have finally come out. And families have been affected by the complications in the mourning process of the families have brought about several problems, not just not just legally, but even in terms of how the families react to the loss. There have been affective disorders, pathological depression, non-depression grief, anxiety that has plagued the members of the family in so long as this problem has continued and festered. The paper also discussed the different laws available locally at this point that we have been using to address enforced disappearance, but that in fact has not been sufficient. There's also been a discussion on the different efforts, at least by the judiciary, in especially introducing the writ of habeas data and the writ of amparo, is to augment the problems and the gaps of the writ of habeas corpus in trying to address the problem of enforced disappearances. Now, the reactions from our speakers, from Attorney Bucar, who represented the chair of the Commission on Human Rights, he had actually pointed out an issue that what he would call questions of protection and the impunity gap, which has also gathered a response from our guest speaker, Congressman Lagman. He has pointed out that the impunity gap he refers to as insofar as people who are not covered by domestic law because they're not party to the convention, they will not ratify the convention, or they're not part of state or an agent of the state. After that, we've had a response from Brigadier General Domingo Tutan, who has reiterated that the AFP and the Human Rights Affairs Office is optimistic of the bill's approval and has committed that the AFP will not be an hindrance to the effective implementation of the bill when it is in fact passed into law. He has emphasized that the efforts of the AFP has so far been not just to train soldiers on human rights and concepts, but to make them understand fully what human rights is all about. He has emphasized that they have been partnering with different organizations, especially FIND and AFAD, and in fact several cases have been referred to his office, and which they have been they've taken steps to look into them. We had the next reactor, Dean Raul Pangalangan, who discussed the phenomenon of the emergence of the enforced disappearances in the late 60s, 70s, and 80s, and the problem of the attribution to the state of the act and responsibility for the enforced disappearances. He further discussed the remedies that have been introduced by the Supreme Court, and that he has called for a review of whether or not these remedies have been sufficient and what has to be done in order to further strengthen them. The next reactor was Ms. Teresita del Rosario, the family member of the first person who has been documented to have disappeared, and his disappearance took place even prior to martial law. What she has pointed out is that even through these years, despite the fact that we have no martial law anymore, we have no dictatorship anymore, enforced disappearances continue to thrive and fester. But the most important thing that she has pointed out is that despite the fact that the Philippines is not yet a party to the International Convention, it still has a responsibility to prevent enforced disappearances and protect people against enforced disappearances. The ratification of the convention is not a prerequisite to the protection of the people. It has to make more of actions rather than promises that it has given so far through these years. And lastly, our friend from the media, Ms. Camolo, has shared with us her experience from the time she was a student journalist writing on human rights violations and enforced disappearances up to the time 30 years later where she still continues to write about them and points out that the problem of human rights violation has continued to thrive, but not just thrive, it even persists despite all the steps that have been taken. Therefore, she's asked that the government should address the problem not just in terms of having a law passed, but having a justice system in place that will fully affect the implementation of the law and to ensure that the people can seek redress and bring cases before it, and that the problems of the people, not just in terms of prosecuting the offenders, but also in terms of giving assistance, recognition of the loss and the suffering, and giving state assistance in recognition of such loss and suffering should also be looked into. And that, my friends, was more or less a summary of what we have discussed this afternoon. Of course, with the discussions and exchanges during the open forum. And thank you.
Thank you very much, Attorney Cristobal. So before we conclude, let's now welcome Mr. Armando Paraga, Fines Advocacy Officer, to read the prayer.
I'd like to say something before we recite the prayer. I think we also prepare some candles to light. We can now get them and light them. Please just be careful. We are inside a... but rest assured, we asked the permission of the technician. So please do take care in lighting those candles. Today we honor the thousands of desaparecidos, not only in our country, but to the rest of the world. At the same time, we would also like to honor the late Mrs. Cecilia Castelar Lagman, who composed or wrote a prayer titled Fines Prayer. And this prayer we would like to offer in honor of the desaparecidos. We may stand, and for those who... And we have some video presentation as well. For our loved ones. When the world becomes exceedingly cruel, when it unleashes chaos and turmoil, when the memory of our disappeared loved ones drives us to searing pain, and we are caught helpless. In its unbridled, unmarshaled power, come to us in your infinite mercy, Lord, and allow us to place our hands in yours. May we find refuge in your loving fold, for there we are safe from the cruelty of this mundane world. When our disappeared kin asked, while being severely tortured, "O freedom, what crimes have we committed in your name?" You alone, O God of history, have heard and understood. You counted by your sacred heart, not by your fingers, the countless crimes of the dictator during the past regime, not the crimes of the desaparecidos, because they had none. We beg you, O Lord,
to protect and guide our loved ones' flight through eternity, while we, their families, seek justice to give them peace and rest. Amen. Mrs. Cecilia Castellar Lagman, fondly called Mommy by fellow human rights advocates, was the courageous mother of 2 martyrs. She was the founding chairperson of the Families of Victims of Involuntary Disappearance, established by 9 families of desaparecidos on November 23, 1985. She died recently due to illness on August 13, 2012, at the age of 92, forever deprived of the truth behind the disappearance of desaparecido attorney Hermon Lagman, missing since May 11, 1977, and the assassination of her youngest son, revolutionary and labor leader Philemon Kapopoy Lagman, on February 6, 2001. Her invaluable contribution and admirable work for the human rights movement continue to keep the flame of courage burning amongst those aspiring for a world without desaparecidos, and where there is respect for human rights and peace based on justice. We will now sit down. Thank you.
It will not take long. Don't worry. Pero from what I understand this afternoon forum, I think everyone will agree with me that the respect for human rights is at the heart of a democratic and free society. And that includes the right not to be subjected to enforced disappearance. We have to resonate or to reiterate this message over and over again, because until today, enforced disappearance continues to happen while cases of the past remain unresolved. Now that we have come to the close of what has been a very enlightening and productive discussion, let me thank everyone on behalf of the Asian Federation Against Involuntary Disappearances, to our honorable keynote speaker, Congressman Dexter Redman, the main proponent of the proposed anti-enforced disappearance law, to our respected presenter, Attorney Bobby Sunga, for sending to us the policy paper on the imperative to ratify the International Convention for the Protection of All Persons from Enforced Disappearance, to our distinguished panel reactors, General Tutaan, Dr. Pangalanan, from the Principal of Law, Ms. Nora Gamolo, a friend from the media, and Ms. Esther Ricardo, the sister of the disappeared, for sharing with us their different, although not necessarily opposing views, positions, or perspectives on this matter. But it seems to me that everyone here agrees that there is a need to explore all possible avenues, all legal means, institutional reforms or measures, both at the international and national level, that will not only adequately address and capture the very nature of this offense, but also to make our government institutions more responsive to the needs of the victims and their families, and to guarantee its prevention and non-repetition. I would also like to take this opportunity to thank our co-organizers, the families of victims of involuntary disappearance, to Nilda, to Joey, and all the fine staff, and the University of the Philippines Institute on Human Rights, Director Arana, and everyone who contributed to make this activity possible. Maraming salamat. And of course, I would like to thank all of you, the participants, for giving us your time, for sharing us your time, and for your contribution in raising the level of the discussion. I could not have imagined a better exchange than seeing all of you here sharing your opinion and insight in the light of finding a better solution to this great human rights issue. I do hope that through this forum, we have reached a common commitment to take part in this advocacy. I also hope this activity leads us need all of us to recognize that we have to work together. We in the human rights community know that we cannot do it alone. We definitely need your help. I assure you that in the coming days, weeks, or months, we will be convening a series of activities to further explore the key issues that were raised today and to bring more voices into this interactive dialogue. On our part, we have tried to reduce the severity of this problem by attacking it from both ends. That is, by openly criticizing the government for not doing enough. At the same time, working with them to make them capable of doing more. Today, let me remind you, is the day that we commemorate the International Day of the Disappeared. There is no better occasion than this day, the UN declared day in tribute to all desaparecidos, to also pay tribute to Mami Lerman. While our hearts grieve with the Lerman family of her passing, but her memory will live in us, will forever live in us, and will serve as an inspiration to continue our work for the cause of the disappeared. Until the day that there are no more families, no more mothers, no more wives, no more daughters, no more friends, and relatives who will have to suffer from not knowing what happened and relatives who will have to suffer from not knowing what happened to their dear loved ones. I believe it's not only our civic duty, but also our moral responsibility to make human rights a reality for all. I urge you to join us in our effort to make enforced disappearance finally disappear. Maraming pong salamat at magandang afternoon.
On behalf of the Youth Institute of Human Rights, thank you for sharing your afternoon. Snacks and refreshments are being served outside. Have a wonderful afternoon.